completed. The security agreements will have to be redrawn, but the most important cost, I think, will be in the procedures involved by the secured parties in bringing their records up to date. They have to know someone's precise name and the correct spelling and their date of birth. They have to know the ACN numbers accurately. They have to know the serial numbers accurately. So they have to get all these records together so that they can complete a proper filing statement and adequately describe the collateral. That's what's going to cost the money in compliance. Now, I struggled with this concept, to be frank, and the only linking theme I can see in those 11 temporary perfection provisions is this concept. In some situations, it will be impossible or impracticable for the secured party to take possession or control or to lodge a financing statement. Or it would be unreasonable to expect them to do so. That's the only linking concept. Give you an example. A secured party may be wanting to claim a security interest in property that is in transit, coming to Australia, hasn't arrived in Australia yet. They can't take possession or control of it yet, and it's not within their range of taking a financing statement yet because they haven't got to that stage. In that situation, they will be given a period of grace of 5 business days. And that 5 business days will generally run from the time the property arrives in Australia and becomes subject to the regime. Generally, these periods of temporary perfection are exceedingly short. They're usually 5 days, 5 business days. And that's the time within which you must register. And if you don't perfect your security interest within that period, usually by registration, you miss out. You're unperfected. You're not protected. You lose priority. So these rules will have to become familiar to us. Thank you. Receivers and managers and other parties will have to check priorities very carefully. For instance, a receiver and manager should check the priority of the security interest under which he or she is appointed before taking appointment. They can do it electronically, easily. They should also do it before distributing any assets. But remember that the financing statement is very brief. It doesn't give you much detail. It tells you the name of the debtor, it tells you the name of the secured party, it tells you the nature of the property that's collateral. It doesn't tell you much. It talks about subordination agreements. Only about 9 matters covered in the financing statement. So to understand the full extent of the security and the full nature of the security and the collateral, you'll need to make inquiries under Section 238. Any interested party can make an inquiry of a secured party. And this will be imperative because remember, the register, unlike the corporations register, does not contain documents. It's just a notice board. The mortgage debenture won't be there, so you can't search it. You're going to have to ask for a copy of that. Ask the secured party for a copy. And if they refuse, you can take them to court. And if they don't comply, their interest is expunged. A pretty severe sanction. So you'll have to do separate inquiries of secured parties to find out the full extent of their security. Now, even that process, yes, sir.
Would that involve having to disclose more funding documents as well as the security interest? Presumably you understand what the charges, you need to know what the liability is.
Yes, yes. The extent of the funding. Yeah. And it's going to be interesting if the secured property is confidential information. We haven't kind of sorted that out yet because that is potentially personal property that could be covered by the regime. So
in essence, any funding document could become the knowledge of any person making an inquiry.
yes, because they've got to determine how much you're secured for. Okay? So it hasn't been tested yet. Nothing's been tested yet. But yes, that makes sense.
So you don't have to have an interest. A member of the public can make that inquiry.
Well, you'd have to be an interested party and you'd have to have a reason for making it. You'd have to have otherwise you'd be fobbed off, legitimately fobbed off. But if you are proposing to lend to the grantor or debtor, or if you are proposing to supply them with goods or services, for example, you would have a legitimate interest in knowing. Banks and so on would have legitimate interest in knowing, so they would make inquiries, and receivers obviously would make inquiries. Receivers will also have to be aware of prior ranking interests. There can be some prior ranking interests that are not on the register, because remember, some interests can be perfected by possession or control, and there won't be any record of that. So they have to be aware of what those interests are, because they could trump them and their secured party. So it's very important to be aware of those. They'll have to check subordination agreements because their secured party might have agreed to subordinate their interest to another secured party and vary the priority that would otherwise be enjoyed under the bill. So they're going to need to ask about those things too. And they'll have to check on interests arising by operation of law, equitable liens, constructive trusts, and so on. Warehouseman's liens. They'll have to check on those, but that's true under the general law now. They have to be aware of those interests that arise by operation of law that are not covered by the bill. The bill is not a code. Thank you. One of the key sections in the regime is the validity, it relates to the validity of the appointment. And the simple proposition here appears in section 233. Unperfected security interests vests in the grantor in the event of an insolvency. And I'm using the term insolvency very generally here. It covers bankruptcy, administration, liquidation, and other forms of insolvency event. Now it's interesting the way they've put that. It's unlike section 266 of the Corporations Act. It doesn't say shall be void as against the liquidator or administrator or trustee in bankruptcy. It says shall vest in the grantor. In other words, back to square one, it's just expunged. So perfection of the security interest is absolutely vital to preserve the interest of the secured party. Now the new regime acknowledges that the effect of section 233 can be a bit severe on some innocent purchasers, lessors or bailors, and it provides protection for them in the form of compensation from the grantor or debtor. But remember, the grantor or debtor in this event is insolvent. So that right to compensation is a right to prove in bankruptcy or liquidation or administration for a dividend. They thought they were fully secured. They finish up with a right to a dividend. So the simple message is you should perfect. The effect of the appointment, I'm going to skip over this because we're running out of time and I do want to take, I'll just stay with it very briefly. I do want to take questions from you at some stage and more questions. Execution creditors, let me just say this, are simply slightly better off under the new regime than they were under the old regime. Certain transferees of chattel papers and accounts receivable take subject to all prior equities. That's very similar to the existing general law at present. The third proposition is a little different though. Where a transferee takes a clear title under the extinguishment provisions because they've taken the title in the ordinary course of business and they didn't have actual knowledge of a breach of the security agreement, they'll get a clear title, but where does that leave the secured party? Well, the secured party will be entitled to the proceeds of sale paid by the purchaser. So they lose a security interest in the property that's transferred, but they get a security interest in the substitute, as it were, the proceeds of sale of the property. Incidentally, proceeds of sale is defined